In the courtroom, the plaintiff Tony Rosamea takes center stage and lays out his story. He begins by explaining that he was referred to the defendant, Tomas Roser, through mutual acquaintances. With a signed proposal in hand, Tony says he drafted the deck plans, submitted them to the local building inspector for approval, and proceeded with the job. According to Tony, the deck was constructed precisely according to those approved plans. He even notes that after some minor issues with cracked 2x2 South, he promptly replaced them, about 50 in total at no extra cost. Tony believed the project was progressing smoothly until, out of the blue, Tomas told him not to return to the property. Tony insists he had already spent time and labor fulfilling his end of the bargain and is now owed the remaining $3,000. He says he's not the kind of guy to just walk away when someone tries to stiff him. Calm but firm, he tells the judge he's here to collect what he's fairly earned. When it's his turn, the defendant Tomas Roser doesn't hold back. With visible frustration, he tells the judge that Tony used inferior materials, specifically number-to-grade lumber, instead of the higher quality number 1 grade they had allegedly agreed upon. Tomas points to the visible buckling of the boards, popping nails, and splinters as proof the work was subpar. He recalls how the building inspector visited the site and, to his embarrassment, actually laughed at the deck. Tomas insists that paying Tony for what he views as shoddy, unsafe work would be ridiculous. He also raises concerns about the construction not being up to code, noting the inspection failed due to joists that exceeded span limits and inadequate concrete work beneath the stairs. From Tomas's perspective, the entire structure was flawed from the ground up, and any professional should have known better. He's adamant that he shouldn't owe Tony a dime for a deck that doesn't meet even basic safety standards. The judge dives into the inspection results with a critical eye, holding up a glaring red sticker that marks the deck as a failure. She reads aloud from the inspector's report, which states that the final joists exceeded the span chart specifications. For number-to-grade lumber, the inspector also flagged the need for a deeper concrete slab beneath the stringers, the part of the stairs that require solid support. As she examines the photos, the judge points out the circular concrete slab that sits too close to the edge, leaving the staircase essentially hanging without proper foundational support. Tony argues that he followed state codes and even tried to reference online resources, but the judge swiftly dismisses that line of defense online. She asks skeptically, pointing out that courtroom evidence must come from a credible authority such as the municipal inspector, not random printouts. The inspector's report is clear: the deck failed, and it did so for serious structural reasons. While defending himself against the accusations of cutting corners, Tony openly admits to using number-to-grade lumber for the joists and beams. He claims it's industry standard and that he's used it in numerous other jobs without issue. According to Tony, the difference between number 1 and number-to-grade lumber is largely cosmetic, maybe a few more knots in the wood, but structurally sound nonetheless. He insists that Tomas never explicitly demanded number 1 grade lumber in writing, and any verbal agreements can be debated. The judge, however, presses him on why he didn't simply ensure that he had proof of their agreement, especially given how easy it is to snap a photo of a contract with a smartphone. Still, Tony holds firm, stating that the lumber used was suitable for the job and arguing that the failure wasn't due to the materials, but perhaps a technical oversight or the inspector being too rigid. His stance is clear: he used what he believed was acceptable and did his best to correct any identified issues. As the tension between the two men builds, the timeline becomes crucial. Tony explains that after Tomas complained about the decking boards, he ordered replacements not once but twice to ensure the customer was satisfied. He says he informed Tomas via text that he was ready to return and install the new 5/4 by 6 boards, but Tomas abruptly shut him down. "Don't come to my house no more," Tomas texted. Tony appears baffled, saying he was doing everything in good faith, yet was denied the opportunity to finish the work. Tomas, on the other hand, argues that he was fed up. He claims the first replacement boards were also unacceptable and that he no longer trusted Tony to do the job right. The judge emphasizes that contractors are typically entitled to a chance. To fix their mistakes, a chance Tomas revoked when he barred Tony from the property. This decision becomes a turning point in the case, suggesting that Tomas may have prematurely cut ties before giving the contractor a fair opportunity to complete the work. As the testimony unfolds, the judge becomes increasingly frustrated with the lack of formal documentation. Tomas claims there was a signed contract but admits he doesn't have a copy. Tony says the materials list and proposal were approved, but can't provide definitive proof of the original lumber agreement. The judge shakes her head, noting that in an age where everyone carries a smartphone, there's simply no excuse not to have records, photos, emails, or even texts that confirm the terms of an agreement. She sarcastically refers to phones as instant copy machines, reminding them how easy it would have been to protect themselves with even basic documentation. This failure to document becomes a core weakness in both sides' cases. The judge also points out that while Tony claims to have texted updates and notices, he didn't save or back them up properly. Tomas presents some texts, but the conversation jumps weeks at a time. In the end, their lack of professionalism in record-keeping makes it harder for the judge to determine who's truly at fault. ***, the judge closely examines the timeline of communication between Tony and Tomas. According to the texts shown in court, there's a notable gap between July 2nd and August 17th. During this time, Tomas heard nothing from Tony, leading him to believe the contractor had simply disappeared. Tony claims he was waiting for the new decking materials to arrive and didn't think it necessary to check in constantly. However, the judge is unconvinced, pointing out that failing an inspection and then going silent for over a month doesn't inspire confidence. Tomas's frustration is evident in his final text, "Do not come to my house or do any work." Tony responds with an aggressive tone, "You don't know who you're messing with." These escalating messages show a complete breakdown of trust. The judge calls out their macho posturing and sarcastically remarks, "Are you guys going to fight in the parking lot?" Ultimately, this lack of consistent communication proves to be a major factor in the case's outcome, showing how bad business practices can quickly spiral into legal conflict. Adding to his complaints about materials and communication, Tomas highlights real-world consequences of the alleged shoddy workmanship. He recalls that his wife actually got a splinter while walking barefoot on the deck, a detail that visibly troubles the judge. Tomas says the surface was rough and full of splinters, a clear indicator that the wood was either of poor quality or improperly finished. He also criticizes the concrete pad installed under the stairs. According to him, Tony simply placed stones on the ground and poured the concrete slab over them instead of embedding it properly into the earth. This method, Tomas says, leaves the pad vulnerable to erosion and cracking when it rains. Photos presented in court appear to support his claim, showing a slab close to the edge, with the stairs not fully supported. The judge agrees that this kind of shortcut poses a safety hazard and likely contributed to the failed inspection. These concerns reinforce Tomas's view that he had every right to reject the final product, though the legal issue remains whether he handled that rejection appropriately. In a critical teaching moment, the judge explains to Tomas a fundamental rule in construction contracts: a contractor must be given an opportunity to cure defective work before being fired or replaced. She points out that inspection failures are not uncommon and don't automatically justify canceling a contract. Tomas, she suggests, jumped the gun by denying Tony access to the property before Tony could address the issues flagged by the inspector. She acknowledges Tomas's frustrations, especially with the delay in communication, but makes it clear that those concerns don't negate Tony's legal right to attempt to fix The judge even questions Tomas's intent, suggesting he may have simply decided he no longer trusted Tony and wanted someone else to finish the job. While that's his right as a homeowner, it doesn't absolve him from paying for the labor. Already done, this point becomes central to the final ruling. Even if the work was flawed, Tony should have been allowed to correct it before Tomas pulled the plug. After weighing all the evidence, the judge issues her ruling. She acknowledges that Tony completed a significant amount of labor and, despite some issues, parts of the deck were functional. However, she also considers the inspection failure, the lack of top-grade materials, and the communication breakdown. Ultimately, she rules that Tomas must pay Tony $1,200 of the remaining $3,000. It's not a full win for either side, but a split decision that reflects the complexities of the case. As both men exit the courtroom, they remain firm in their views. Tomas says he regrets ever hiring Tony and now has to spend another $2,500 to fix the deck. Tony, on the other hand, insists he did solid work and believes he deserved more money. The episode closes with a reminder from the court's host that whether it's verbal or written, every agreement should be clearly documented and every party deserves a chance to make things right before the matter ends up in court.